When the matter came up in court on 17 November 2022, the following counsel appeared for the parties: Mr. Kibet for the petitioner, Mr. Munene for the first respondent, Mr. Nyamwange for the second respondent, Mr. Karanja for the third respondent, Mr. Kihoro for the fourth respondent, whose brief was held by Mr. Nyamwange, and finally, Mr. Bitok for the interested party. Mr. Karanja informed the court that the third respondent had filed a notice of preliminary objection hereinafter PO in regard to the jurisdiction of this court over the subject matter. He informed the court that the order of 11th November 2022 had been served upon the respondents on Monday, 14th November 2022 in the afternoon, and that the vetting stopped immediately upon service of the said order. All counsel for the respondents and the interested parties indicated that they were in support of the PO, and upon listening to all counsel, including counsel for the petitioner, the court directed that the PO be heard and disposed of first before any other business in the matter. It was further directed by the court, with the concurrence from all counsel for the parties, that the said PO be heard by way of written submissions. The first respondent also filed a PO of even date, raising the same or similar issues to those raised in the third respondent's PO. In the PO, the third respondent raised the following three issues for determination by this court. A, that this honorable court has no jurisdiction to deal with the matters raised in the petition and the application, that is the notice of motion dated 11th November 2022. B, that the petitioner has no locus to bring this petition. And C, that the petitioner has not exhausted the administrative and other legal avenues available before approaching the court. Counsel for the third respondent filed his submissions on 18th November 2022, while counsel for the first, second, and fourth respondents filed on 17th November 2022. Counsel for the petitioner filed his submissions in opposition to the PO on 21st November 2022. So what are the counsel for the respondent saying about all this PO? Mr. Karanja, for the third respondent, submits that the petitioner is challenging the constitutionality of the nomination of the interested parties as chief officers by the first respondent on the recommendation of the fourth respondent. Counsel notes that the petitioner was not an applicant for any of the same positions, and he is not an employee of the fourth respondent, or indeed any other of the respondents. Counsel submits that the jurisdiction and mandate of this court, that is ELRC, is marked and delineated under Article 162, Sub-Article 2A of the Constitution, and Sections 2 and 12(1) and 2 of the Employment and Labor Relations Court Act. Counsel submits that for a matter to properly come before this court, there has to exist an employment and/or labor relationship between the parties in the subject matter. Counsel has cited various cases, among them Republic versus Karisa Chengo and another, 2017, and Attorney General and two others, versus Okia Omtata Okoiti and 14 others, 2020, to buttress the argument that this court must down its tools at this point for lack of jurisdiction, advocate the interim orders issued on 11th November 2022. On the issue of locus standi, counsel submits that the petitioner has failed to demonstrate the legal capacity in which he has filed this petition. Counsel argues that since the petitioner has not demonstrated that there exists an employment and/or labor relationship between him and the respondents, and bearing in mind the jurisdiction of this court as stated above, that the petitioner lacks the legal standing to file this petition. In support of the foregoing argument, counsel has cited Nick Ithinji Dishu versus the clerk, Kiambu County Assembly, and another, 2014, and urges this court to find that there existed no employment and or labor relationship between the petitioner and the respondents or any of them, and hence the petitioner lacks the requisite legal foundation on which to stand in filing this petition. On the third issue of failure by the petitioner to exhaust all the administrative and legal avenues available to him before filing this petition, Council submits that on 1st November 2022, the County Assembly of Nakuru, which is not a party in this petition, put up a notice in 2 local dailies with the national circulation calling for members of the public to submit any information, memorandum, or petition under oath that may have a bearing on the suitability of the nominees, that is the interested parties, for appointment as chief officers. Council submits that since the petitioner is not one of the nominees and in any event he had not applied for any of the positions, that was the opportunity for him to express his objections to the suitability for nomination of any, some, or all of the nominees in support the same with evidence before the County Assembly. Council cites Section 7, subsection 10 of the Public Appointments County Assembly's Approval Act as providing for a channel through which the petitioner should have written to the County Assembly clerk forwarding whatever evidence and all protestations that he has against any, some, or all of the nominees. Council has cited the Speaker of the National Assembly, as Honorable James Jenga Karume, and Jeffrey Muthiga Kabiru and 2 others, Pastor Samuel Monga Henley and 1776 others, in driving home the point that where the law provides for administrative channels to be applied in resolving an issue, parties shall follow those channels to the end before resorting to court process. Council argues that the petitioner has clearly and evidently failed, refused, and or neglected to follow and apply the administrative channels before coming to court. Council has urged this court to apply the doctrines of exhaustion, constitutional avoidance, and judicial restraint, and hence refrain from dealing with a matter whose administrative procedures and processes have not been exhausted. In winding up its submissions, Council argues that the interim orders issued by court on 11 November 2022 was directed at stopping the County Assembly of Nakuru from carrying out the vetting of the interested parties, yet the County Assembly is not a party in this petition. He argues that the Speaker of the Assembly, that is the third respondent, is only the leader of the Assembly but cannot be equated to the Assembly. For all the foregoing reasons, Council for the third respondent submits that the PO should succeed and the petition be struck out with the costs. Mr. Munene, for the first respondent, premised his submissions on a PO dated 16 November 2022. The said PO raises similar and or the same issues raised by the third respondent as summarized in the foregoing paragraphs. Council submits that the petitioner has not exhausted the administrative and legal procedures provided for in sections 4, 7, and 8 of the Public Appointments County Assembly's Approval Act, sections 8 subsection 1A and 45 1B of the County Governments Act, and Standing Order 97 of the Nakuru County Assembly Standing Orders. Council further argues that the issues raised in this petition are not in the purview of this court by virtue of the provisions of Section 12 of the Employment and Labor Relations Court Act, as no employer-employee relationship has been disclosed or an employment and or labor relations issue identified. He submits that this court must refrain from stopping the respondents from performing and executing their constitutional and legal duties and mandates. Council has cited Mukisa Biscuits and Company Limited, First West End Distributors Limited, on what constitutes a proper PO, and has submitted that the PO by the first respondent meets the criteria. Urging this court to down its tools for lack of jurisdiction, Council has cited owners of motor vessel Lillian S. versus Caltex Oil Limited. Council submits that this court cannot take the role of the County Assembly in determining the suitability of the interested parties to be nominated and vetted for the various dockets of chief officer. Council emphasizes on the doctrine of separation of powers and urges this court to be very restrained. He submits that there is not yet an employer-employee relationship between the respondents and the interested parties, and hence the issue raised by the petitioner do not fall within the jurisdiction of this court as delineated under Article 162, Sub-Article 2 of the Constitution and Section 12 of the Employment and Labour Relations Court Act. Council submits that the petitioner should have forwarded and submitted his grievances to the clerk of the County Assembly for legal and administrative action. According to Council, that is the avenue that the petitioner should have taken. Council has cited several cases, including Shadrach Koskei and another versus Governor of Nakuru County, that is Governor of Nakuru County, and two others, 2016, Kenya National Council of Employment and Migration Agency, and another versus National Police Service Commission, and others, 2016, and Trusted Society of Human Rights Alliance versus the Attorney General, 2013, to drive the point home. On the doctrine of exhaustion, Council has cited Christopher Mutinda Mutua and another versus Alfred Mutua and 11 others, 2019, Anthony Miano and others versus Attorney General and others, 2021, and Speaker of National Assembly versus Honorable Jenga Karume, 208, among many other decisions, to illustrate that since the petitioner has failed to exhaust the legal and administrative procedures provided for, the petitioner should have no audience with this court as he is in abuse of the process. Council argues that the nomination of the interested parties by the first respondent does not amount to appointment, and that some or all of the nominees may be rejected by the County Assembly. He argues that there is as yet no employer-employee relationship between the interested parties and the respondents, or any of them, and as such, the matter is without the jurisdiction of this court. On this argument, Council has cited Public Service Commission and 4 others, versus Cheruyot and 20 others, 2022. Council argues that just like the national government, county governments are independent organs which should not be subjected to unnecessary interference in performance of their constitutional, legal, and administrative functions. He has cited Simon Wachira Kagiri versus County Assembly of Nyeri and 2 others, 2013, among several other decisions in support of that proposition. On the basis of the foregoing, Counsel for the first respondent has asked the court to strike out this petition with the costs. Mr. Nyamwange, for the second respondent, submits that the petitioner has not exhausted the administrative and legal avenues available to him before filing this petition in the court. He has cited Attorney General and 2 others, versus Okiawa Mtata and 14 others, 2020, in support of this submission. Counsel has associated himself with the submissions made by Counsel for the other respondents in support of the PO and pleaded that this petition be struck out with the costs. Mr. Kioro, for the fourth respondent, associated himself with the Counsel for the other respondents in support of the PO. He submits that the petitioner is free to present a petition of protest to the County Assembly through the clerk thereof for consideration in case he has any objection to any, some, or all of the interested parties being vetted and or appointed to the office of Chief Officer. Counsel pleads that this petition is premature and not ripe for court adjudication as the petitioner has not exhausted the administrative process. Mr. Bitok, for all the interested parties, indicated that he was not filing any submissions and that his clients were in full support of the PO. He associated himself with submissions by counsel for the respondents. Now, what does the counsel for petitioner say about all this? Mr. Kibet, for the petitioner, sets out the facts that in September 2022, the county secretary invited applications for persons suitably qualified for the position of the chief officer in various dockets. Applicants were shortlisted and interviewed, and thereafter the 21 interested parties were recommended to the fourth respondent for nomination, who in turn forwarded their names to the county assembly, which is not a party in these proceedings, for vetting and approval. The vetting was to take place between 14th and 17th of November 2022. Excuse me. Council submits that the petitioner is of the view that the process leading up to the nomination of the 21 persons was neither fair nor transparent and credible. He submits that the 9th, 15th, and 18th interested parties were nominated for dockets that they neither applied for, shortlisted, nor interviewed for. Further, council submits that no person or persons living with disabilities was nominated, and that no persons or person from marginalized communities was nominated. Council submits that the petitioner has taken issue with the nomination of the 9th and 15th and 18th interested parties who were nominated for dockets that they neither applied for nor interviewed for. Council submits that the process of application, shortlisting, interviewing, nomination, and vetting shall eventually lead to appointment and hence employment of the interested parties by the county government of Nakuru. And thus, according to the petitioner, this is a matter within the jurisdiction of this court. Council submits that the issues raised in the petition relate to and are actually matters of employment. He has cited Kriv Nyaga Ogwara versus Governor Nyamira County and two others, 2021, Spindle Interfreight Kenya Limited versus Labor and Social Relations and two others, 2019, International Center for Insect Physiology and Ecology versus Nancy McNally, 2018, United States International University versus Attorney General, 2012, and Daniel N. Mugendi versus Kenyatta University and three others, 2013, among others, to buttress the argument that so long as a matter relates to employment and labor, this court has constitutional jurisdiction over any matter that relates to rights in employment and or labor relations and issues connected therewith. While insisting that this court has jurisdiction in this petition, counsel argues that in the unfortunate event that the court finds that it has no jurisdiction, it should not strike out the petition, but rather order a transfer of the same to the appropriate court. He has cited the Interfreight case and the Daniel Mugendi cases cited above in support of that proposition. On the issue of locus standi of the petitioner in bringing this petition to court, counsel has cited the enlarged scope of persons who can file a constitutional petition for violation, breach, or threat to the Bill of Rights under Articles 22 and 258 of the Constitution. He has cited International Community of Women Living with HIV, registered trustees, versus Coordination Board and two others, 2021, and Jonathan Munene versus the AG and two others, 2021, in support of that position. On the allegations that the petitioner has not exhausted the administrative process and options on the issues raised in the petition before coming to court, counsel submits that the petitioner is complaining about the designation and inclusion of the 9th, 15th, and 18th interested parties as nominees for dockets that they neither applied for nor interviewed for, and that the entire process is contaminated with irregularities and illegalities. He argues that those are constitutional and legal issues that beg for the intervention of this court. For the foregoing reasons, counsel for the petitioner argues that the issues raised in the petition are ripe for hearing, and that this court has the requisite jurisdiction to hear and determine the same. He prays that the POs be dismissed with costs. Now, having said all that, what are the issues that are in contest here? This court has carefully gone through the pleadings and the submissions by counsel for all the parties as analyzed and summarized above. In the considered view of this court, there is only one issue for determination in the POs raised by the respondents. And the issue is, does this court possess the requisite jurisdiction to hear and determine the petition and any other proceedings pursuant thereto? To paraphrase Nyarangi, Judge of Appeal, in Owners of Motor Vessel Lilian S. versus Caltex Oil Kenya Limited, jurisdiction is everything to a court. It is the clothing that enables and allows a court to rise to the occasion and sit in the sacred arena of justice in a matter. Without jurisdiction, a court labors in vain. Any orders and or pronouncements made by a court without jurisdiction amount to nothing and are mere nullities. Once the issue of jurisdiction is raised in a matter and the court realizes that the issue is prima facie probative, the court has to deal with the same immediately before dealing with any other issue or issues in the matter. If upon consideration of the issue of jurisdiction, the court makes the finding that it has no jurisdiction in the matter, the court must down its tools and make no further step in the matter. The issue of lack of jurisdiction of a court should be raised at the earliest opportunity to arrest a situation whereby the court may labor in vain by issuing orders that turn out to be mere nullities and amounting to nothing. The issue of jurisdiction should primarily be raised in the pleadings and or by way of appeal, as it has happened in this petition. The jurisdiction of a court flows from the Constitution or the statutes. See the decision of the Supreme Court in Samuel Kamau Macharia and another versus Kenya Commercial Bank and two others, 2012. The limitations in jurisdiction may be based on the subject matter or by territory. The latter does not apply in this petition, as this court has unlimited territorial jurisdiction similar to that of the High Court. The Black's Law Dictionary, 10th edition, defines a court's jurisdiction as a court's power to decide a case or issue a decree, also termed as competent jurisdiction. What I understand all the respondents to be saying in their submissions by counsel is that this court lacks jurisdiction over the subject matter for a number of reasons. One, that the constitutional and statutory jurisdiction of this court does not cover the issues raised in the petition. Two, that the petitioner has not exhausted the administrative and or legal avenues available to him before lodging the petition, and hence the matter is not ripe for adjudication by court. Three, that the issues raised by the petitioner are not justiciable based on the doctrine of separation of powers. And number four, that the petitioner lacks the locus in filing this petition. On the first ground, the respondents have submitted that this court lacks constitutional and statutory jurisdiction to hear and determine this petition. On the other ground, that is ground two, the respondents are submitting that once the petitioner has exhausted the administrative and legal avenues provided for in the law, this court may then consider the issues raised. On the third ground, the respondents are of the view that unless there is prima facie evidence of abuse and or violations of the law, by the respondents, this court should keep off the business of the respondents based on the doctrine of separation of powers. Thirdly, the respondents have raised the issue that the petitioner lacks locus standi on which to file the petition. They submit that the petitioner was neither an applicant for the vacancies of chief officer, nor is he an employee of the respondents or any of them. Now, the question of the jurisdiction over a matter before a court of law goes into the core business of the court. And if a court finds itself to be without jurisdiction over the subject matter, it shall down the tools and take no more step in the matter. The respondents, and rightly so, have raised the issue of jurisdiction at the earliest opportunity available. Now, what is the jurisdiction of this court? Article 162 of the Constitution provides as follows, and I quote, "The superior courts are the Supreme Court, the Court of Appeal, the High Court, and the courts referred to in Clause 2. Now, sub-article 2, Parliament shall establish courts with the status of the High Court to hear and determine disputes relating to, I only deal with A, employment and labor relations." And I had the quote there. To ring-fence the jurisdiction of this court, Article 165, sub-article 5, denies the High Court jurisdiction over matters that fall within the jurisdiction of this court. To operationalize this court as a specialized court, the Parliament passed the Employment and Labor Relations Court Act. Section 12 of this Act provides for the jurisdiction of this court. The preamble to the Act states that it is, and I quote, "an Act of Parliament to establish the Employment and Labor Relations Court to hear and determine disputes relating to employment and labor relations and for connected purposes." End of quote. For avoidance of doubt, Section 12 of the Act provides for the jurisdiction of the court as follows. And I will read just the first one, that is Section 12, subsection 1. The court shall have exclusive, original, and appellate jurisdiction to hear and determine all disputes referred to it in accordance with Article 162, sub-article 2 of the Constitution and the provisions of this Act or any other written law which extends jurisdiction to the court relating to employment and labor relations, and I underline this one, including, and then it states from A all the way to J. I will not read that because it's the law and it's what it is. There is now a plethora of decided cases to confirm and clarify that this court has constitutional mandate and jurisdiction to deal with constitutional petitions and judicial review proceedings so long as such proceedings concern matters within the jurisdiction of this court, as enumerated and delineated above. Such decisions include the USU versus the Attorney General cited above, Daniel M. Mugendi and others versus Kenyatta University, also cited above, and also Isipe versus Nancy McNally, also cited above, among many other decisions. In the considered view of this court, the identifying mark in a matter that is within the jurisdiction of this court is that there has to be an employer-employee relationship or a process leading to or aimed at creating an employment and or labor relationship and matters connected therewith. In other words, may it be an ordinary employment and labor relations cause, a constitutional petition, or judicial review proceedings, the subject must be concerning an employment and or labor relations for this court to have jurisdiction. In such proceedings, in my view, the claimant, applicant, or petitioner need not be an employee or employer, especially in view of the extended boundaries on who can petition on violation, breach, or threat to the Bill of Rights under Articles 22 and 258 of the Constitution. However, regardless of who brings the matter to court, the question must be whether the issues concern employment and labor relations. It is my considered view that while the jurisdiction of this court is limited and specialized to employment and labor relations matters, the preamble to the Employment and Labor Relations Court Act, as reproduced above, clearly indicates that this court has jurisdiction to deal with the matters connected and or incidental to such relationships. What comes to mind is, for example, recruitment process. If a petitioner or a claimant complains about the recruitment process that is intended to create an employer-employee relationship, should this court sit back and tell such a litigant to wait until there is created an employer-employee relationship to file the complaint or claim in court? Is recruitment not a matter or a purpose connected with and or incidental to employment and labor relations? In human resource management, recruitment is a process of identifying, selecting, hiring, and onboarding employees. It is in the considered opinion of this court that it has jurisdiction to entertain issues of recruitment as such matters are related, connected, and incidental to employment and labor relations. It is a process geared towards creating employer-employee relationship and hence an employment and labor relations issue. There is no way that this court can run away and abdicate its duty in dealing with such matters. In any event, the list of the matters spelled out under Section 12, subsection 1 of the Employment and Labor Relations Court Act on the jurisdiction of this court is not exclusive and or exhaustive, and the word including has been deliberately used preceding the list. Applying the above findings to the facts of this petition, it is a considered view of this court that the application, shortlisting, interviewing, nominating, vetting, and appointing are all matters connected and incidental to employment and labor relations. The process that the interested parties are undergoing is intended to culminate in the employment of chief officers in the county government of Nakuru. This court agrees with the holding in Usiu case and Daniel N. Mugendi cases above, among many others cited by the learned counsel for the parties herein, to the effect that whether in an ordinary course, constitutional petition, or judicial review proceedings, this court has jurisdiction to deal with all matters connected or incidental to employment and labor relations. In regard to the subject matter, therefore, this court finds and holds that it has the requisite jurisdiction to hear and determine this petition. On the issue of locus standi, this court finds and holds that in view of the provisions of Articles 22 and 258 of the Constitution, the petitioner has the legal and constitutional capacity to file and prosecute this petition. It is not disputed that the applicant is a member of an organization of persons living with disabilities, a constituency he alleges has been ignored and or marginalized in the recruitment process. He states that he is a citizen of Nakuru County and a Kenyan and of necessity a taxpayer for that matter. It is the considered view of this court that the petitioner has the requisite constitutional and legal standing in filing this petition. He need not to have applied for the positions on offer. It is my view that this petition is in the purview of public litigation. However, the respondents have raised the issue as to whether this matter is properly before this court based on the doctrine of exhaustion. Closely related to this issue is the doctrine of separation of powers and whether this court should interfere with the business of the respondents in the recruitment process. It is not in dispute that the clerk to the National Assembly of Nakuru did issue a notice on 1st November 2022 inviting members of the public, the petitioner included, to submit any information or evidence by way of petition or otherwise bearing on the suitability of the nominees for appointment as chief officers. This fact is not disputed. The petitioner has not in any way demonstrated that he submitted any complaint or petition in whatever form raising the issues and complaints that he is now raising through this petition. The petitioner has not given any explanation why he has not done so. Be that as it may, does the fact that the petitioner did not file his misgivings on the nominations with the county assembly invalidate his constitutional right to approach this court by way of this petition? In my opinion, the answer is an emphatic no. The Constitution is the supreme law of the land, And in any event, the provisions cited by the respondents in Section 7 of the Public Appointments County Assemblies Approval Act and the Nakuru County Standing Orders allowing the petitioner to lodge his complaints with the County Assembly for an appropriate administrative action are not couched in mandatory terms and cannot in any way override the Constitution. In his petition, the petitioner is raising constitutional and legal issues concerning the process leading to the nomination of the interested parties. The issues relate to discrimination against and or neglect of persons with disabilities and marginalized communities in the said nominations. He is also alleging that some of the nominees were nominated for dockets that they neither applied for nor were they interviewed for. The alleged illegalities and irregularities were allegedly committed by the respondents. It would be improper and illegal for this court to order the petitioner to lodge his constitutional and legal concerns with the same respondents who are alleged to have committed the acts complained of. It would amount to calling upon the respondents to sit in their own case and or on their appeal. That would be against the rules of natural justice, Article 47 of the Constitution, and the various provisions of the Fair Administrative Action Act. All this court is aware of the decisions in the Speaker of the National Assembly, versus Honorable James Njenga Karume, and Jeffrey Muthiga Kabiru and others, versus Samuel Monga Henry and others cited above, among many other decisions cited by counsel for the respondents. This court takes the view that where the issues raised in a petition concern threat, violation or breach of constitutional provisions, and that is the case here, then the Supreme Law takes the lead and the precedent. This court agrees with the decision in Evans, Landtema, Mswahili versus Vihiga County Service Board and two others, to the effect that the administrative action envisaged in the above cited statutory provisions are not mandatory and cannot override the right of the petitioner herein to approach this court for adjudication of the legal and constitutional issues raised in this petition. Inasmuch as this court agrees with counsel for the respondents that courts should not unduly and unnecessarily interfere with the operations and functioning of the respondents, in the same token, courts should not sit back in the face of alleged violations of legal and constitutional provisions by any person or body, as adjudication of such breach. The doctrine of separation of powers does not operate in a vacuum. This court notes that the County Assembly, which is carrying out the vetting and is supposed to recommend appointment of the interested parties, is not party in these proceedings. However, that may not be fatal to this petition, as this court can still adjudicate on the matters as between the parties before it. Moreover, the parties are free to apply to amend their pleadings at any time along the way, and such applications shall be considered on merit. In the circumstances and for all the reasons foregoing, the POs raised by the respondents are found to have no merits and are hereby dismissed. On the costs, as stated elsewhere in this ruling, this court takes the view that this petition is in the nature of public litigation. Clearly, the petitioner did not file this petition in personam, but in rem, so to say. He filed the petition for common public good rather than for personal gain. For that reason, this court orders that costs be in the cost. So what orders do we make here? This court issues the following orders. A, the preliminary objections by the respondents are found to have no merits and are hereby dismissed accordingly. B, the petition and the other proceedings shall proceed to hearing on merit and on priority basis. And C, costs in the cost. So, counsel, that is what the court was able to come up in the ruling, and those are the orders that we make. It is not in dispute that the clerk to the County Assembly of Nakuru did issue a notice on 1st November 2022 inviting members of the public the petitioner included, to submit any information or evidence by way of petition or otherwise bearing on the suitability of the nominees for appointment as chief officers. This fact is not disputed. The petitioner, however, argues that the period given for filing of such petitions was deliberately shortened to deny him and the public in general an opportunity of presenting the petitions or objections in whatever form or manner. He states that he wrote to the secretary of the first respondent on 4th November 2022 seeking for some details ostensibly to enable him to prepare his petition to the county assembly, but the said letter has not been replied to this day. The petitioner submits that in the circumstances he had no alternative other than to approach this court via this petition. The petitioner has insisted that the issue is not per se about the suitability of the interested parties, but rather the legality and constitutionality of the entire process, from where it began to where it has now reached. He argues that those legal and constitutional issues cannot be adjudicated upon by or in the county assembly. This court agrees with the counsel for the petitioner that the constitutional mandate of this court to adjudicate on the issues raised in this petition cannot be ousted by the statutory provisions cited by counsel for the respondents on the administrative process. I agree with the decision in Evans, Randitema, Mswahili versus Vihiga County that statutory provisions shall not oust the constitutional mandate of a court. As noted elsewhere in this ruling, the petitioner is challenging the constitutional and legal validity of the actions taken by the respondents in allegedly declaring non-existent vacancies and procedural shortlisting, illegal and irregular interviewing process, and hence imminent constitutional and illegal appointments. The petitioner has pointed out specific provisions of the Constitution that he alleges to have been violated, and he argues that he deserves a hearing on those issues. In the considered opinion of this court, the issues raised by the petitioner cannot be wished away or submitted to the respondents to deal with. It is for this reason, among others, that this court holds the considered opinion that this petition deserves a full hearing and the appeals raised are not merited and are therefore hereby dismissed. Referring the constitutional and legal issues raised in this petition for determination and or consideration by the county assembly and or indeed any of the respondents, body or entity would amount to this court abdicating its legal and constitutional mandate, duty and obligation. For this reason, the appeals raised by the respondents are hereby dismissed. As stated elsewhere in this ruling on costs, this court takes the view that this petition is in the nature of public litigation. The petitioner has not filed this petition for his personal gain. If we go by the pleadings, he has filed the petition for common public good rather than for personal gain. For that reason, the court orders that the costs be in the cost. And therefore, the court issues the following orders. The preliminary objections by the respondents are hereby dismissed. The petition shall proceed to hearing on merit and on priority basis, and the costs of the appeal shall be in the cost. I think we have done tremendous justice, and that's what this process is about, so that at least we have a ruling which one can appeal against, one can, we leave it at that. We hope that we will be able to see through these matters as quickly as possible. So thank you, everyone, and enjoy the rest of the day. So the court adjourns.